In today's lecture, we would like to discuss another important aspects of law, and that is relating to competition law. And before discussing about competition law, exactly what was the scenario before independence of India, as certain particular industrial units or certain industrial houses or business houses were playing a monopolistic role or trade practices as such. For example, in the field of iron and steel industries, the Tata Iron and Steel Company Limited at Jamshedpur was playing a monopolistic role in the field of manufacturing and producing steel and iron in India, also in the field of consumer goods such as Hindustan Lever was playing a dominant role in the field of consumer products, and in regards to that, to break the monopolies of certain trade practices after independence, the government of India was at its own initiative established steel and iron manufacturing plants and units at Rourkela and also at Vilai and Bokaro, also at Visakhapatnam, to restrict or to break the monopoly of the Tatas in the field of iron and steel. So also certain other industrial houses, they emerged to break the monopoly of the Hindustan Lever, such as the Godrez, and in this way the break of monopolies and the restriction of trade practices was initiated after the first decade of 5 year planning, which was launched in 1950s and which continues, and in the first and second decade of the planning, India in the field of growing economic and social development was for industrialization, and for industrialization India adopted the very policy of liberalization, and in consequence of adopting the policy of industrialization for socio-economic development of the country, many business houses or industrial houses, they started and launched their respective ventures and established various industries and factories, and in consequence, as we found at present, there are so many industries or business houses, such as in the field of manufacturing and production of steel, cement, drugs, pharmaceutical, and also in the field of automobile, etc. And due to the adoption of the policy of liberalization, now almost we found thousands and thousands players in the market in the field of manufacturing and producing different industrial products, also consumer goods, etc. And in the second decade, to break and to restrict monopolies, the parliament and government enacted the Monopolies and Restrictive Trade Practices Act 1969. So, as such, the very Act of 1969, which restricted the growth of monopolies in the market, India now boasts of contemporary competition law which is on par with established competition principles of the world. This transformation was initiated with the launch of the Competition Act in the year 2002. The Act is now known as the Competition Amendment Act of 2007, thanks to the amendments enacted during that year. So, the very purpose of encouraging competition in India is that the Indian economy is consistently on the rise with a few setbacks, which are a part and parcel of every economy. This economic growth is triggered by competition as the vigor to better the competitor plays a catalytic role in unlocking the potential of growth in vital areas of the economy. A competitive yet healthy environment facilitates fair competition in the market, thereby not only prevailing the national economy but the global financial system as well. So, in regards to that, we found the very objective of the Competition Act as provided under the Competition Act of 2002. So, the very following objectives are brought in to prevent practices that are detrimental to competition, to promote and sustain competition in the markets, to safeguard the interest of the consumers, to ensure freedoms of trade carried out by other participants. So, exactly as under Section 7 of the Competition Act of 2007, as it is known now, the Competition Commission of India was established so as to prohibit anti-competitive agreements and abuse of dominant position by enterprises. Moreover, the establishment aims to regulate combinations such as mergers, amalgamations, or acquisitions, courtesy of a process that includes inquiry and investigation. The commission is constituted of a chairman and other members whose total strength could be a minimum of two and a maximum of six. Such members are appointed by the central government. The amendment of the Competition Act in 2017 led to the creation of the Competition Appellate Tribunal. The entity was established to adjudicate appeals against the order of the Competition Commission of India and to determine the compensation claims arising out of the Commission. The tribunal is not existence at now. So the changes brought forth into this Companies Act 2013 under Section 401, the very powers of the Competition Appellate Tribunal are now vested with the National Company Law Appellate Tribunal, which comprises of a chairperson and three judicial members. So the very responsibility of the National Competition Commission that we found those responsibilities of the commission. The commission is empowered to eliminate practices which are detrimental to competition, promote and sustain competition, safeguard the interest of the consumers, and ensure freedom of trade by other participants. And also another responsibility of the commission is to inquire into the matters of concern. And so also another responsibility of the commission regarding issuance of interim orders in case of anti-competitive agreements and abuse of dominant position which would temporarily restrict any party from pursuing such an act. So also, another most important responsibility of the commission is competition advocacy to provide a clear depiction of the provision the central and state government may make a reference to the commission while formulating any policy on competition or other relevant affairs. The reference may state the opinion on the possible effect of such policy on competition, though the opinion of the commission is not binding on the central government, and as such, the very amendment of 2007, which provide another very framework, and that is regarding on the very backdrop of economic developments and liberalization promoting the Indian fraternity to allow both international and domestic competition into its market. So the amendment of 2007 resulted in the following, that one is this Competition Commission of India was designated as a regulator for the prevention and regulation of anti-competitive practices in the country. So also it provided there must be that this Competition Commission of India must be intimated through a notice in the event of any merger or combination within a span of 30 days, and penal consequences have been prescribed for failure in issuing the notice. A competition appellate tribunal was established, but the entity ceased to exist in due course of time. And as such, under the Act, Section 3 prohibited of anti-competitive agreements in between the industrial or business houses in regards to monopoly, and also Section 4 prohibits abuse of dominant position of any business house or industrial units or industrial houses in connection to monopoly in the particular trade or business, and Section 5 provides combination of enterprises and persons. So the very combination of enterprises and persons are regarding acquisition, merger, and amalgamation, and as such, Section 6 of the Act provides regarding regulation of combinations, and Section 49 provides competition advocacy. So the very elements of company law that portrayed as under Section 3, Section 4, Section 5, Section 6, and Section 49 of the Act. So the very elements we could summarize as anti-competitive agreements, abuse of dominant position, and also in regards to merger, amalgamation, and acquisition control and competition advocacy. So, what exactly anti-competitive agreements and how it is prohibited under Section 3? Anti-competitive agreements are contractual obligations that restrict competition, and as such the very provisions pertaining to the same are provided in Section 3 of the Competition Act 2002. The Act prohibits any agreement connected with production, supply, distribution, storage, and acquisition or control of goods or services as it may cause an appreciable adverse effect on the competition or competitive scenario of India. So, as per Section 3, Subsection 2 of the Companies Act 2002, any anti-competitive agreement within the meaning of Section 3, Subsection 1 is void. The entire agreement is deemed void on the existence of anti-competitive clauses, which has an applicable adverse effect on the competition. Here is a list of stipulations stated under this prohibition, and those stipulations are: the first one, no enterprise, association of enterprises, person, or association of persons are allowed to enter into any agreement associated with the production, supply, distribution, storage, acquisition, or control of goods, provision, services, as it may potentially cause an appreciable adverse effect of competition within India. Any agreement that contravenes these provisions shall be declared as void. And another stipulation is that any agreement between enterprises or association of enterprises or persons or association of persons or between any persons and enterprises would be declared as void. Also, any agreements amongst enterprises or persons at various stages or levels of production chain is different markets connected with production, supply, distribution, storage, sale, or price of it, or trade in goods or provisions of services. So also, another restriction and prohibition under the Competition Act of 2002 is relating to prohibition of abuse of dominant position as under Section 4 of the Competition Act of 2002, where exactly dominant position as specified in the Act is a position of strength enjoyed by an enterprise in the relevant Indian market. It facilitates the independent conduct of operations of competitive forces in the relevant market, the influencing of competitors, consumers, or relevant market in its favor. So, no enterprise or groups are permitted to abuse their dominant position, as exactly under Section 4, Subsection 2 of the Act, which specifies the following acts as an abuse of a dominant position, and such as direct or indirect imposition of unfair or discriminatory conditions or price in sale and procurement of goods or services would be considered as abuse of dominant position. So also curtailment of the production of goods or services or that of technical or scientific development pertaining to the goods or services would be considered as abuse of dominant position. So also involvement in a practice that results in the denial of market access to any other producer, manufacturers, or business houses or industry would be considered as abuse of dominant position. So also, drawing conclusions to contracts based on acceptance by other parties of supplementary obligations which is not associated with the subject of such contract would be considered as abuse of dominant position as provided under Section 4 of the Act. So also utilization of the dominant position in one relevant market to either enter into or protect another relevant market would also be considered as abuse of dominant position. The powers of determining the eligibility of any enterprise or group to enjoy a dominant position is vested with the Competition Commission of India. And it may be noted that the more existence of dominant position must not be categorized as a dominant position unless the dominance is abused by such entrepreneur, industrialist, business houses, manufacturer, or producer. So now we will discuss the very provisions as provided under Section 5 under the Act regarding combination of enterprises and persons in the field of in regards to acquisition, merger, and amalgamation. So exactly it is being prohibited and the very combination and its regulation are provided under Section 5, which exactly provides that of the Competition Act of 2002, it prohibits a person or enterprise from entering into a combination that could result in an applicable adverse effect on competition within the relevant Indian market. On the other hand, if any person or an entire enterprise desires an entry into any combination, a notice requesting this same shall be addressed to the Competition Commission of India. The notice specified in the details must include the details of the proposed combination. The form must be submitted with the prescribed fee within 30 days of the approval of the proposal pertaining to merger or amalgamation or execution of any agreement or other documents required for acquisition purposes. Again, the Competition Commission of India is the body that is empowered to determine whether the disclosure made under Section 6, Subsection 2 of the Competition Act of 2002 is appropriate or if the combination may potentially have an appreciable adverse effect on the competitive affairs of India. And another important feature under the Act is regarding competition advocacy, which is provided under Section 49 of the Competition Act of 2002. So, competition advocacy forms an integral part of the competition law. The provision facilitates the central government, state government to have the opinion of the Competition Commission of India on the potential implication of the policy on competition or other affairs. For this purpose, the concerned governments may make a reference to the Competition Commission of India, upon the receipt of which the latter will issue its opinion within 60 days. The government may then formulate a policy which it considers to be appropriate. The Act also entitles the Competition Commission of India to adopt suitable measures for the promotion of competition advocacy. Moreover, it is aimed at creating awareness and rendering training of competitive issues. So now we would like to discuss as some provisions of the Competitive Competition Amendment Act of 2007. So the very Competition Amendment Act 2007 amended the Competition Act 2002. The amendment introduced several changes such as mandatory reporting, and as such, the Act under this particular change made it mandatory for certain mergers and acquisitions to be reported to the Competition Commission of India. And the second change that is relating to notice period. And as such, the combination was not effective until 210 days after the Competition Commission of India was notified or after the Competition Commission of India approved or rejected the combination. And the third change is regarding punishment. The Amendment Act proposed more deterrent punishment for contravening the orders of Competition Commission of India. And another important change and amendment that was made regarding establishment of the Competition Commission of India and the Competition Appellate Tribunal, and also another regarding that the Competition Commission's advocacy. So, the very amendment of 2007 as broadening the competition advocacy as provided under Section 49 of the Act of 2002 to include the word or culture after competition advocacy. So, the next change that was made under the 2007 amendment is regarding compounding of certain offences. The Act inserted a new section, Section 59A, to make certain offences compoundable. And now we'll discuss the next major amendment made to the Act, that is Competition Amendment Act of 2023. So, the Competition Act of 2023 was published in the Gazette of India on April 11, 2023. The Act introduced a new concept called the Deal Value Threshold or DVT, which will come into effect On September 10, 2024. So, what exactly those amendments that we would like to deal, and as such, the very amendment of the 2023 of the Competition Act of 2002 would be called as India's antitrust law, stricter security, new thresholds, and faster approvals. So, India's competition law landscape has undergone significant updates as on September 10, 2024, following more provisions of the Competition Amendment Act 2023 coming into effect. These include the deal value threshold or DVT and Clause F of Section 19, which provide greater clarity on the mergers and acquisitions landscape in India. Overall, the amendments to the competition law have strengthened the Competition Commission of India, granting it increased autonomy to regulate anti competitive practices. So, in that regard, we would like to discuss as regarding the very amendment of 2023, the latest amendment, the Competition Commission of India now requires companies with significant operations in India to notify the regulator of mergers and acquisitions and amalgamations, which are collectively called as combinations, as provided under Section 5 of the Competition Act of 2002, and also that exceed 20 billion Indian rupees. This follows the Ministry of Corporate Affairs setting this threshold under the Competition Amendment Act 2023 with provisions to define substantial business operation. So the key changes include more business-friendly regulatory environment requirements for cross-border compliance, enhanced oversight, clear deal value thresholds, and faster decision-making process according to the country's legal opinions. It reflects a modernized and efficient approach to competition law in India, promoting the to ease of doing business while ensuring robust regulatory checks. So, what exactly the deal value threshold means? The deal value threshold is a new concept introduced in the Competition Act through the 2023 amendment and will come into effect on. And already it was now in effect as it was in the Gazette notified for its effect to be on September 10, 2024. So now it is already in effect. The amendment specifies that the merger and acquisition deals worth over 20 billion Indian rupees now require approval from the Competition Commission of India, provided the target company has significant business operation in India, and as such, this threshold value ensures high value deals are renewed to prevent anti competitive practices, particularly in the digital sector, addressing concern over big data and privacy issues. also another important, that is in regards to assets and turnover limits. Combination under India's Competition Act refer to mergers, acquisition or amalgamation that meets specific financial threshold related to the asset or turnover of the practice involved. Prior to the Competition Amendments Act, combinations were primarily assessed based on criteria like the size of the combinations and the size of companies merging or being acquired. So, in this regard, we found some other important changes in the very Competitive Amendment Act, which provides some other important in respect to those changes made in regards to the Amendment Act of 2023. So, besides, it is otherwise, as already we have discussed, brought significant changes to India's antitrust legal framework. So, as we have discussed, this new threshold requires approval from the Competition Commission of India in regards to mergers and acquisition deals worth over 20 billion Indian rupees. The deal value threshold applies only if the target company has substantial business operations in India. This amendment aims to prevent anti-competitive practices, especially in the digital sector. And also, it expanded the very definition of combination. The Act definition of combination has been broadened to include organizations that help farm cattle. This gives the Competition Commission of India more authority to access a wider range of merger and acquisition deals. And another mechanism provided under the amendment of 2023, as it allows enterprises under inquiry for anti-competitive agreements or abuse of dominance to seek resolution through mutually agreed remedies or commitments. This aim to reduce the time and resources spent on investigation and litigation, which is simply called settlement and commitment mechanism as provided under the said 2023 amendment. And the very act is being implemented in phases. Some provisions, including the deal value threshold, already came into effect. So, in this way, the very amendment made substantial changes in regards to acquisition, merger, and amalgamation, and also which is commonly known as combination under the provisions of Section 5 of the Act. And in regards to that, the very amendment of 2023 introduced the deal value threshold and the Saturn reviews timelines and cross-border compliance, anti-competition agreements, also dispute resolution, It also clarified merger and acquisition rules. So, the very amendment of 2023 brought substantial changes in restricting and prohibiting monopoly trade practices in India. And in this regard, we would like to discuss certain important landmark judgments, and that those landmark judgments we would like to discuss in our upcoming lecture.